Welcome and good morning or good afternoon, depending on which part of the world you are joining us for the first Knowledge Rights 21 webinar on the topic of open norms. I am seeing that there are still some people coming in, so we will wait for maybe another minute before starting with our discussion. I'm Felix Reda. I'm a member of the Policy Committee of Knowledge Rights 21, and I will be moderating today's webinar. So, as the last people are coming in, I would like to invite our speakers to turn on their cameras and we can get started. So first of all, a few words about Knowledge Rights 21 and why we are here today to discuss the topic of open norms. Knowledge Rights 21 is an Arcadia-funded program by IFLA, by LIBA, and Spark Europe to promote a progressive copyright agenda with a particular focus on the needs of libraries, research, and cultural heritage. And Knowledge Rights 21 has been looking to provide research and advocacy support for a number of most pressing issues in the copyright field in this area. So the access to ebooks, both in the public library sector as well as for research purposes, enforcing the rights of users against contractual override or technological protection measures in copyright, open access research issues such as secondary publishing rights and rights retention mechanisms in different countries, as well as exceptions and usage rights under copyright law, with a special focus on open norms, which is the topic of today's webinar. So open norms in copyright law that provide flexibility for users without the need for permission have been somewhat neglected in the European Union, but they are gaining a lot of importance internationally. So today in the webinar, we want to hear perspectives from Taiwan, from Japan, and from Europe, and see if the EU is really as hopeless as some say when it comes to the topic of open norms and what we can learn from copyright reforms in other parts of the world. Before jumping right into the discussion and introducing our speakers, we've decided rather than giving a general introduction, we will show you a very short 1.5 minute video animation that has been created for the Knowledge Rights 21 program in order to introduce the topic of open norms and what they are good for. So I would like to invite Stephen to bring up the video. Thank you, Stephen. There is a link available to the video, and it's under a CC license, as you just saw. So perhaps Stephen can share the link in the chat, and you're more than welcome to reuse it for your own activities. So jumping right into the discussion, I would like to present and welcome our speakers. First of all, to give us a perspective on open norms in the Taiwanese copyright system, we have Professor Chung-Lun Shen joining us from the College of Law at National Chenchi University in Taiwan, where he is Associate Dean and Distinguished Professor of Law. He's also appointed as a lecturer by the Taiwan Intellectual Property Court and Intellectual Property Office, where he works at the Petitions and Appeals Committee of the Ministry of Economic Affairs to review patent and trademark appeals made by the Intellectual Property Office. Second, sharing a perspective on open norms in Japan, we have our very own Benjamin Wright, who is co-chair of the Knowledge Rights 21 Policy Committee, and also PhD researcher at the Center for Intellectual Property Policy and Management, with a focus on copyright and artificial intelligence, and also member of the UK Intellectual Property Office Research Experts Advisory Group. He recently spent 4 months in Japan on a foundation scholarship based at Waseda University, researching the introduction of open norms into Japanese copyright law. So he's going to be able to offer us a fresh perspective there. And last but not least, our third speaker giving a perspective on the situation in Europe is Professor Emily Hudson of King's College London, and previously the University of Melbourne, University of Queensland, and the University of Oxford. Professor Hudson is the author of Drafting Copyright Exceptions from the Law in Books to the Law in Action. So without further ado, I would like to hand over the floor to Chung-Lun Shen for the presentation and to bring up the slides. Thank you.
Thank you. Good morning, everybody. Felix, Ben, Emily, and Stephen. Thank you. The band invite me, and I have give me opportunity to present the Taiwanese experience regarding fair use provision. So I think the Taiwan has been, making best effort to contribute to harmonization of international intellectual property law. So I am also happy to work with today. We have other distinguished speaker here today. So let me share my slide for everybody to start my today presentation because time limits. So I just do my best to meet with the rule for today's webinar. Okay, so this is my slide. So I play this. Okay. Everybody, today my topic is survey, reflection, developments, fair use provision under Taiwan Copyright Act. Why would say fair use provision? Because we have the parallel model. Is one is like the American fair use doctrine, codification in our Copyright Act. We have another parallel. When another model is learn from Europeans the statutory limitation exception. So it's called this fair use provision to cover the two things. Today, content for everybody shared to everybody is firstly, I think it's very theoretical perspective for fair use, especially fair use doctrine. The second one, I was bring everybody to see historical development of Taiwan fair use legislation. And then I would notice, special address the latest amended Copyright Act for long distance teaching and digital collection of library in 2022. I think the part of the amend clauses, I think the main purpose want to deal with the issue about, the COVID-19 threat. So everybody locked up in the room. So we must access to platform for teaching, for studying. So that's why, 2022 legislator is consider this the situation as a meta policy to pass the Amendment Copyright Act. The last, I think, is a couple minutes to reflection, Taiwan Supreme Court recent development on fair use. But I think it's time, consider time. So I just a couple minutes to share it with everybody. So let's go start from jurisprudence of authoritative fair use in Taiwan. We have parallels, the model, the fair use, the doctrine. I think you want to reconcile two conflicts interests. So firstly, we talked about fair use. The very important thing is we should carefully watching the substantial substitution effect of infringing products. Otherwise, it was enrolled, I think, economic interest originally enjoyed by copyright owner. The second one, even you using someone's copyright word without authorization, the fair use function to make sure your creation is beyond original markets the copyright owner enjoy. So sometimes we add up some condition for you must have created new content, new purpose like American case law to justify your fair use. And I think the third point very important because the copyright is not like patent right. So the mechanism of economic market cannot sell cannot mean everything. So especially our goal of legislation for copyright is one to promote cultural social development. So that's why we fair use sometimes is have the function to alleviate the impact of market value because mechanism of economic market cannot do that. So fair use sometimes is have this kind of purpose. Okay, that us up to the international contest authority. I think everybody know very well. Berne Convention Article paragraph 2, Article 9 gives authority 3-step test. And then we have Article 13, the TRIPS agreement is extend just reproduction right to all kind exclusive right. Okay, that's I think it's a serve very important jurisprudence for Taiwan, the legal system on the especially on fair use provision. So that's what why here to mention about U.S. European like OIA mentioned about this Taiwan a parallel system. We have one side to using like American fair use doctrine. Also, we have a European statutory limitation exception. The U.S. is I think the special thing for Article 106 is 4-factor test. 4-factor sometimes the case law is focused on the whether you used even without authorization from this copyright owner, it is transformative. So first factor directly connect with the 4-factor. The important thing is if you are your work is the transformative work, sometimes have the less impact upon the current market, potential market, even the value of copyright word of the copyright owner. So transformative thing is also, we have the couple cases regarding the transformative, how to interpret transformative, especially we face the new business model, new creative style, something like that, very important. So I think with the we have the distinguished speaker talk later, but also Taiwan 44 to 63, we have enumerated model limitation exception. We have the two kinds of thing. I think especially I should address here is the paragraph 5 of Article 5, paragraph the 5th paragraph of the 2001 Copyright Directive. I think it is just the inherent jurisprudence from international treaty context right here to check justification of the exception and limitation. The Taiwan hybrid model. So firstly, Article 44 to 63, we have enumerated provision for limitation exception like like European model. Also, we have Article 65 is for fact text, like the U.S. law, like the fair use the doctrine. So everybody can will be curious about how the very distinguished the two legal model can work together. So I just explained it for everybody. Under Taiwan court law, if you turn in terms of the Article 65 is the fair use doctrine. According to our legislatives, the Gore, we have the two purpose for the fact test. The first one is if you find the wording of the reasonable scope under Article 44 to 63, even they are the statutory limitation exception. The legislator asks the court to apply for fact text to check whether your activity or your activity is within the reasonable scope. Check whether it's reasonable. So first function for fact test is try to check upon reasonable score. So it's very important interaction for the two parallel the model here. The second one for fact test is the function according to our legislator is the policy consideration. In one to the for fact tax 34 new time limitation exception is beyond provision Article 44 46 to 63 because we face the new business model, new creative style, technology. So when we're talking about for example, licensing or infringement, we should a very important tool to deal with this. It's beyond the expectation of legislation when is the codify this the enumerate provision for limitation exception. So our Article 65, I think, is wording is similar to that of American 106. So I should address the two things for everybody. The first thing is our fair use doctrine cannot be applied to moral right. So even you can observe fair use for your using someone's copyright work without authorization, but it cannot exempt for you from this violation of moral right. The first thing is like this, but I think according to my observation, U.S. law is not this way. And another thing I should address here is we asked even you are a fair user, you should provide clear indication source, the source of work. So this is not precondition for exemption, but if you fail to do that, you will violate Article 16, our moral right. It's a name, pseudonym, the name, something like that, you violate that, you constitute another infringement on that. It's according to our core experience. So then this part is regarding historical development. So from 1990, originally Taiwan's adopt European style like enumerate the provision limitation exception. But from 1992, we have Article 65, but at that time, very different from today's the function. At that time, it's like the general principle. You want to observe provision, fair use on the statutory limitation exception. The court must use the for fact text to check whether your activity is justified. So at that time, 1992, I think Article 65 is very baseline, very important to even you want to have the exemption from the Article 44 to 63 statutory limitation exception. You must use the general principle to check upon again. 1998 extending the fair use cover new type used, but ever I can look at 2014 is now current authority. So this currently parallel interpretation, and we use the 4-fact test for fair use to check upon the reasonable scope of the your activity when you observe the fair use from statutory limitation and exception. So that's my organizing the whole interaction between the two parallel model each other from here, because I cannot the class by class to show everybody. So that lies the is the overall picture for everybody. Okay. So now latest the bill amendment is not passed yet. The legislator want to complete excluding statutory exemption from application for fast tax, except for private copy. So in the future, may in the action very narrow, just limit to private copy. Private copy still as remain having the reasonable scope rewarding there. Other classes, original, we have the original task with is the reasonable scope would be deleted. So this our movement, but this bill has not been passed yet. So we have today the speaking today for this. The very important thing is to show everybody regarding our latest amendment Copyright Act for long distance teaching and digital collection library in 2022. As I mentioned, with the mainly main purpose our legislation is try to deal with the issue of COVID-19 online teaching. So Article 46 amend to accommodates online teaching. As the content is content is saying regarding like the digitally transmission of word, but very important thing is the reasonable scope would delete to separate from evaluation fair use doctrine. I think is policy oriented amendment. You don't want the court uncertain, is have the uncertain prediction on this the function of this Article 46 when we face the threat of COVID-19. So also we have Article 46 bis. It tries to broaden the online teaching to education purpose. The Article 47 is along with your teaching is to try to justify editing a textbook for purpose education, something like that. Also reasonable was the lid. And Article 47 is the cover digital correction copy work library. So the Article 46, everybody look at the paragraph 1, is original text. At that time, I think before the amendment, we have the score necessary for purpose. So, but this led the necessary score, how to interpret this is led to court to make the decision. But so court should be do it as tax to make sure as to how to determine whether act for violation exclusive are justified. But paragraph and Article 46 with is because the teaching platform is school, so school someone run into some risk of direct and indirect infringement. That's why with the parallel we have the school and teacher. But how about student? From this, the text is the 46. I can see any indication from this text is the exempt student from the downloading, the copy course. Maybe student want to find another way to have the fair use. The 46 paragraph 2 is this this amendment. This is amendment to cover. It's not just the reproduction download. Is cover public broadcasting and publicly transmission. But it's set up the precondition, for example, on this violating script right is try to ask the the school to prevent a copyright infringement. So if I look at if the reasonable technical measure has been adopted to prevent access by person not registered in school, not to enroll in this course as exemption tag effect. You have the fact exemption, but it's compared with paragraph first, we have extra precondition here. Also, it's the paragraph 3 also is extra obligation for the school and teacher. If I look at this, the very complicated here, but easy, I make it easy. If I look at Article 44, is the proviso as the mutatis mutandis to this Article 46. So if I look at I underline, provide this should not apply where such the reproduction would prejudice interest, economic right holder to type, the use, work, and volume method reproduction. According to my studying on this, paragraph 3, I think the two implications. The first one is create a duty due diligence for school teacher that should choose this harm way to achieve this teaching purpose. Another one, I think, precisely requires school teacher to follow mechanism for market for use unless such a result bring about excess burden for teaching purpose. So this extra burden, but I doubt for about is the provision would be maybe it's to hinder our function of Article 46, the how to interpret this this harm, or how to set up reasonable school obligation on the paragraph 3, Article 46. I think in the future, maybe the court to do that. The 46 bis, I don't want to spend too much time on this. It's just extend is just the teaching purpose to purpose education, very broad. So very broad, I think is Chris right is public broadcast and public transmission. So it's very important as condition here, provide this should not apply if there is profit seeking activity, because the purpose of the education on the surface as you have the broader interpretation of that, then compare with the Article 46 for teaching purpose. So there also have precondition, but it's either way, either use the set up the technical preventing measure to prevent copyright infringement, or you should pay equitable remuneration for use. Okay. The 47 easy for everybody is preparing the textbook. I must address here as the textbook as the required by law and regulation to exam, compile, preparation, produce something. So it's the limit to the textbook is the required by law or government. So according to the policy of Taiwan Ministry of Education, the Ministry of the Ministry in Taiwan usually ask the NGO to prepare textbook for elementary school, for high school. So that's why we have Articles 47. This has the narrow application of this, after this article. It's not applied to all textbook as the specially required by law and regulation. Okay. And then with Article 40A is regarding museum and the national public, the library. So everybody can look at the comment here. So firstly, Article 40A, library museum can copy correction to facilitate justified purpose according to necessary defined by provision. Also, we have the National Central Library can produce something for specific purpose to promote national cultural development. And we also have the provision regarding perusal by public transmission within library and museum. It's allowed about subject to restriction on quantity copy using the same time and prevention of transmission. So 40A bis is regarding abstract copy. So the central local government agency, NGO, or appointed NGO, you can copy abstract for master thesis, academic paper, research report. Okay, so that's the 4 article I just mentioned as our latest amendment. Jeff, now is that just to share everybody for the extra for our teaching purpose or some teaching studying for student, for everybody. So Article 51 is our provision of private copy. Article 52 is the the quotation where necessary for report, comment, teaching, research. But if I look at it, we have they have the same wording within the reasonable scope. So Article 53 is just for disabled person. So it's a very special policy-oriented provision for their using, especially for there's the learning, the disabled person, you want to learn to study the material is by using the special device to do that. So I think Article 53, firstly, you want to this kind of the work can be exploited by local central government agency, something like that, is to serve as the education purpose for the disabled person. Also, it can.
We are running a little bit short on time, so I'm just giving notice.
Okay, thank you, thank you, Felix. The second paragraph is the mutatis to this person as among the disabled person and their guardians for the personal nonprofit use, and also is have the distribute. It can be distribute public transmission among the 3 kind of party. So Article 33 is regarding special purpose. So its party concern is the 3 party and facilitate use the work by disabled. So very important thing for our education purpose. So Article 54 is for exemption question. You can reproduce, or you can reproduce the someone's word to make exemption question. But this examination should have held by central local government agency, so limited to this kind of occasion. So first part, I think a couple minutes, maybe 1 minute, 2 minutes to reflection. The U.S. case law, very important thing, maybe to create a milestone for future fair use. The Google article, everybody know the fact very well. The article is the Google is a copy articles declaration code and developed. And they developed this implementation code themselves, but using this declaration code as the rule to create a new thing. The U.S. Supreme Court say is the fair use. Another case I think I watched very carefully is Andy Warhol. As a visual art, someone, I think the infringer is using copyrighted photo to add up some new feature of visual art on that. So you want to ask for the exemption under fair use the doctrine, but court say it's not fair use. So everybody look at the blue highlight here is the court very, very brief reason for its decision. The Taiwan is very controversial, as Taiwan has a very famous art. After that is the descendant to collect as work, but not just the paper base. It wants to compile something for memory of this famous author. But someone without authorization, it just give you is make up this digital version of his collections. So at this copyright litigation, the infringer also asked for the Article 65 fair use. It say I That's why the reason why I do that is just to preserve and promote as the, if authors the collection, because I don't think you have descendant have the plan to digitize this version. So I do that. So this is asked for fair use. So fair use, of course, say is fair use. So it's very controversial, it's highly criticized. Another reason for this fair use is to protect public interest. So I think this should be examined again, reviewed again on the future maybe academic work. So sorry, I'm over time, and I just brief out all the development of Taiwan fair use for everybody. Thank you, everybody. Thank you. As for your comment and question, thank you.
Thank you very much. And we will jump right to Ben's presentation on the situation in Japan. And I also invite participants to leave questions and comments in the Q&A tool.
Oh, okay. Thank you very much, Felix. Can I just check that you can see my slides? Okay, wonderful. So as Felix explained, I spent 4 months last year in Japan researching the introduction of open norms with a particular sort of view on artificial intelligence. And what this presentation is going to do is it will set out the reason that they decided in 2018 to introduce 2, arguably 3 open norms. I'm only briefly touching on one of, I'm focusing, sorry, mainly on one of the articles, briefly on the second, and I'm actually ignoring the third because it doesn't, to my way of thinking, actually introduce an open norm in terms of how it's been codified. So I'm going to talk about the background. I'm going to introduce the exceptions. I'm going to do a little bit on jurisprudence, and then I'm going to state some of the examples which I think are permissible under this exception, and perhaps we can think, and many of which I do not believe are permissible under the Information Society Directive or indeed under the European Copyright Key. So first of all, Japan, a civil law jurisdiction, introduced 3 open norms in 2018. And the background to this was really economic. I'm not aware of any substantive debate around whether open norms are sort of work within a civil law jurisdiction. It was driven really by economic considerations and social considerations. So Japan, as we know, is identified with high tech, and in terms of AI, they are global leaders in driverless cars and also robotics. But also societal issues were at play. So Japan, I think, has the highest aging population of any country in the world. Of course, we're all facing environmental issues, but Japan is rare compared to most European countries, although of course with the tragedy that's gone on in Turkey, not that rare. But Japan is one of the most tectonically active countries in the world. And essentially, this has all been, in terms of industrial policy, been sort of put under the banner of Society 4.0. So a post-industrial society where technology is used to support society. So a firm economic grounds to the introduction of open norms. Interestingly, in the early 2000s, I can't remember whether it was 2001 or somewhere between 2001 and 2003, the then Japanese Prime Minister Koizumi created the Intellectual Property Strategy Headquarters. So he determined that intellectual property was so important to the Japanese economy that it created this IP strategy headquarter chaired by the Japanese Prime Minister and and it incorporates all the cabinet members. And one of the often cited drivers for the 2018 changes was Japan, a global technology leader in terms of manufacturing, was falling behind primarily in search markets. So an often given example was that Japan, there were companies investing in indexing and search. However, they fell behind because copyright did not allow the kinds of activities that one associates with search. Thus, the United States, with their servers and businesses based in the States, were able to get a steal over domestic Japanese companies. And anyone that's been to Japan and looks at the advertising, it is predominantly dominated by domestic companies. So the fact that a sort of economic superpower has fallen so behind in e-commerce markets, I think was a sort of a shock to the system. So sort of around this time, 2003, because of these issues around e-commerce and Japan falling behind, you started to see, particularly amongst academics, a discussion around Japan fair use. So i.e. not US fair use, but the prospects of a fair use system introduced that was specific to the legal tradition, the cultural tradition, the business traditions of Japan. And this led in 2008 to the Intellectual Property Strategy Headquarters to ask the relevant government departments to sort of look at fair use and whether Japan should introduce it. And around this time, and Japan is interesting in the fact that it is constantly updating copyright law. Every few years, every 2-3 years, you'll get a new amendment to the copyright law. And so in 2009, when Japan was the first country in the world to introduce an exception for AI and data analytics and data mining, they introduced some other exceptions, and they classified exceptions into 3 different silos. So on the left-hand side, acts which would not normally be viewed as prejudicial to the interests of rights holders, and as you can see, many of them are technology related. 2, acts where possible harm to the interests of rights holders were perceived, but they would be minor in effect. So here we see sort of the snippets that we see in Google Books and plagiarism services. And then thirdly, public interest exceptions, which may conflict with the marketplace of rights holders and their legitimate interests, but they are required because of public policy goals. So you got this thinking around 2010 about different sorts of exceptions, and the fact that certain exceptions did not affect rights holders' legitimate interests at all. Then in 2016, again, the IP Strategy Headquarters asked the Cultural Affairs Office, Agency of Cultural Affairs, to sort of look at the issue of fair use. And this resulted in a highly influential survey, huge numbers of respondees, as you can see, and 63.8% of listed companies that responded were in favor of flexible norms, and 17%, and sort of quite interestingly, if you look at this survey, respondees were only 17% supported a fair use type test, an open-ended exception with little or no guidance, whereas 68.6 wanted a flexible open norm which incorporated some indication of lawful uses. And really, this is what shaped the final recommendation in 2018 and the decision to reject fair use, because they felt that people wouldn't use it because it didn't offer guidance. The received wisdom is that Japanese companies are litigation averse, so they felt it wouldn't be used. But they've come up with a hybrid sort of exception, as we can see. And again, I would say, based on interviews, that within Japan, the introduction of open norms was well supported. There was opposition to US style fair use coming from American entertainment industry lobbyists, but within Japan, the introduction of an open norm was well received. So the two exceptions that were introduced, the one I'm going to really focus on is 34. So exploitation without the purpose of enjoying the thoughts or sentiments expressed in a work. And actually, if you look at the enumerated uses in that exception, we can see that AI is allowed. We can see that the use of copyright works when undertaking research and development is explicitly allowed. And use of copyright works where there's no human perception is explicitly allowed, in addition to similar uses which do not result in human enjoyment of the copyright works. The other open exception, Article 47.4, is again, as we saw in the previous penultimate slide, sort of incidental uses, where the main usage, as it were, is elsewhere, and however copyright works are used. So again, these are sort of highly technical uses, computers, networks, but do include snippets. Oh, sorry, no, snippets are a different one, but snippets, again, I think fall under 34. So as a result of this sort of 2010 kind of categorization, you saw the thinking develop further, and the introduction of open norms that are, in the case of the top one, or in fact, arguably both, have no effect on the legitimate interests of right holders in the view of the legislature. So 34, this is the text in terms of the sort of opening paragraph. It is permissible to exploit a work in any way and to the extent considered necessary in any of the following cases. I've just given the three cases: AI, research and development using copyright works which do not involve human perception of the copyright works, or in any other case in which it is not a person's purpose to personally enjoy or cause another person to enjoy, making available communication to the public, the thoughts or sentiments expressed in that work. So again, it's about enjoyment. So if you enjoy intellectually or emotionally the thoughts and sentiments, that is the purpose of copyright, and therefore that falls away and is not covered by 34. But where there is no enjoyment or perception by humans, then this is the special case, using the words of the Berne Convention. This is what this exception allows. However, this does not apply if the action would unreasonably prejudice the interests of the copyright owner, the third step of the three-step test, in light of the nature or purpose of the work or the circumstances of its exploitation. So, and then this is what these are the enumerated examples. So again, R&D using copyright works, AI, including for commercial purposes. We've already seen that this exception allows communication to the public. And then 3, where there is no human perception of the work. So these are the given examples that are explicitly permitted, but other uses are also permitted. Oops, Other uses are also, I don't know what's going on here, sorry about this. Other uses are also permitted as long as it doesn't result in the enjoyment, intellectual or emotional enjoyment of the works by human beings. In the interests of time, let me just skip this slide so we've got more time for discussion. This is just sort of bringing out some of the similarities and differences with fair use, so I shall ignore this. 34, yeah, let me ignore that. We've already covered this. So from a jurisprudential perspective, this is, I think, very interesting. In UK law, if you look at Information Society Directive and the copyrighted key, you perhaps can read in the purpose of copyright in any way you want to. It's not very clear. In the United States, one looks to the American Constitution for the purpose of copyright. The purpose of copyright in the United States is to promote science and the useful arts, as they were called at the time. So in the United States, you know the purpose of copyright is utilitarian. It's to promote science and learning, etc., etc. It is not primarily, of course it does, but the prime purpose is the public interest in societal advancement. It isn't the protection of individual rights holders. And by dint of Article 34, as a result of Article 34, what we now know in Japan is the legislature has defined the very purpose of copyright to be the protection of works when they're for the purpose of enjoyment by a human. So where this isn't happening, then it is not a restricted act. Where there is no human perception, then the act is fair and it is covered by the exception as a non-infringing act. I've already covered this, that the introduction of open norms according to interviews was well received across all stakeholders in Japan. We do know that the American industries lobbied against it, as they did in Taiwan, again, and South Korea and Israel, etc., etc. So finally, sorry, how much time have I got? How am I doing for time?
About 2 minutes.
About 2 minutes. So this is the end of the presentation. This is just giving an example of some of the actions which I believe, in addition to the enumerated examples, are probably allowed. So reverse engineering, but not limited, as is the case in Europe, to interoperability. Forward engineering, using the ideas and maybe even software, as we've seen in Google versus Oracle, to then create your own software. You know, creating databases as a service, I think, is permissible under this exception. Full text, I think, snippets, etc., is lawful. Plagiarism services lawful. Malware analysis lawful. I mean, in Europe, if you look at the Information Society Directive, the indexing of by search engines is not explicitly lawful either. Indexing by search engines is arguably covered by other areas of law, but you know, one would expect in 2022 that 2023 you could look at your copyright law and say, you know, the way the internet functions is lawful, which I'm not sure that the copyrighted key would pass that test. Other uses arguably that are lawful, offering services related to medical device data, proprietorial medical device data, thumbnail images, sharing links, repairing, updating, and improving software produced by third parties. So lots of uses which are not so easily accommodated, I think, under the Information Society Directive in Europe. Very, very quickly, contract override is not clearly laid out in Japanese law. I think there's been a view recently that the AI aspect of 34 probably is not overridable by contract. Technical protection measures, copy control measures in Japan are only applicable for private copying. Access control circumvention is lawful if it's for research purposes, commercial and non-commercial research, or otherwise does not harm the interests of the owner of the copyright. So again, sort of a liberal regime around technical protection measures. And that's it. Thank you very much.
Thank you very much, Ben. And then I'll hand the floor to Professor Emily Hudson for the view of open norms in Europe.
Just trying to share my slides.
Yeah, we can see them.
Can you?
Yeah.
Okay. Thank you. Because I can't see them. Let me just.
I can see half a slide, so maybe.
Yeah. Sorry, when I first tried to do this, it said somebody else was still sharing. So let me just stop and.
Maybe start over.
Apologies. All right, let me just get that. Thank you. All right.
In the meantime, while we get it working, feel free to also use the question and answer tool, and then we will have some time for discussion at the end of the presentation.
Have you got all of
now
them
it looks
Bill?
perfect.
Wonderful. Okay. Well, I feel like I was to an extent gazumped by the cartoon to begin with, which covered a lot of key points. But what I might do is add a bit of nuance to that presentation with my sense of what's happening in Europe. And that's right, you've got an academic who originates from Australia, who's now in the UK, talking about the European perspective. So, but we'll see how we go. So let's get started. And I guess the first question I wanted to ask was quite a high level one, like why flexibility? I think as seen in the discussion we've already had, there's been ongoing concern in countries around the world that existing exceptions are not up to the job. And often the concern is that those exceptions are too narrow, too prescriptive, to fulfill their functions of enabling socially beneficial uses and the creation of new works. And rule-like drafting is said to cause all manner of problems. So, for instance, lack of clarity in the content of the law due to ambiguous language. So you might have language that doesn't map onto industry practices, concerns that provisions can be prone to redundancy because of changes in technology and norms, and also just that rules can be under-inclusive, that conduct that ought to be covered by a free exception is excluded. And for those who support greater flexibility in copyright exceptions, an important next step in their logic is often to say these issues are inevitable under any model which revolves around detailed exceptions. Legislators simply do not have the time and the foresight to craft exceptions to deal with every possible contingency, and therefore we need to open up the system through the use of flexible standards. And what I'd like to do is just pause for a moment on what flexibility means as a drafting matter, because one way of understanding flexibility is by reference to the degree of precision that rules are more specific and standards are more open. But this slide sets out a slightly different way of thinking about standards and rules, and it suggests that the main difference between a standard and rule is when the legal consequence of a particular scenario is determined. So that is, you have a rule if you know in advance what would be the legal consequence of that behavior. An example given repeatedly in the standard and rule literature relates to speeding offences. So if you know in advance that it is an offence to drive your car above 30 miles per hour down a particular stretch of road, that is a rule. And so the job for the judge in that scenario is mainly to find the facts. So they make factual determinations and then the legal consequence follows. Whereas for a standard, the role of the judge is also to give some content to the law. So for instance, if we had a provision which said it's an offence to drive at an excessive speed, the judge would have to figure out what excessive means in addition to all these factual determinations. Now, one question is whether this model still holds in a civil law system, because a lot of the people who write about standards and rules come from a law and economics tradition that has its roots, has its origins in the United States. My sense is it does, because judicial decision-making is not the same as judge-made law. So the common law system, which judges can originate the law and not just interpret it, that's not what we mean when we say judicial decision-making. We mean that the job of the judge is to actually help interpret what the statutory language means, or what the language of a legal command means, to give it content. So they're not just deciding facts, they're also crafting legal consequences. But I'd be very keen for those of you in civil law systems who want to disagree to please jump in to correct me or add the nuance. But speaking of nuance, I think another thing to bear in mind is that standard rule and rules exist on a spectrum. So we can have more standard-like and more rule-like forms of drafting. And furthermore, that standards and rules can each be simple or complex. So for instance, thinking about fair use in the US system, that's a multi-factor standard. Fair means, and then you've got 4 fairness factors listed in the statute. Whereas if you want something even purer, you would just say fair. It needs to be a fair use with no direction in the statute of what fairness means. And it's also important to bear in mind the importance of interpretive practices. If we had a legal rule, if we had a command which prohibited vulgar behavior, is that a standard or a rule? And Kaplow says, well, if we all know what vulgar behavior is, it's a rule. So one of the things to try and tease out is when we're talking about we want openness and flexibility, what is it that is our concern? Because as I'll discuss, I think that if our concern is drafting problems, that there's an issue with lack of clarity due to poorly drafted terminology, that could be remedied by a standard, but also could be remedied by a better drafted rule. If the scope of exceptions is under-inclusive, that might be remedied by a standard, but again, we could just write better rules. And finally, if our concern is obsolescence, then maybe that's where standards do have a more obvious benefit over rules. But I think we've just got to be clear, if we're concerned about the European position, what exactly is our issue? And I think the other thing to bear in mind in relation to Europe is all these added complexities because of the complexities of the EU lawmaking context. So I might jump down on this slide. We can be very happy to come back to some of the challenges with fair use. But let's talk about the challenges in the EU system. And again, I feel that the video did a great job of setting some of these out. So I'll just put a bit more meat on the bones. So as indicated in the earlier video, we have the Information Society Directive in Article 5 setting out a list of cases in which member states may or must provide for an exceptional limitation. So that list needs to be read alongside the DSM directive, which adds a couple of more compulsory exceptions. But as noted in the video, member states can choose which cases to implement. And furthermore, they have discretion in how they do that. So there seems to be, well, at least in some instances, the Court of Justice has told us that particular cases in Article 5 are not measures of full harmonisation, which means that member states have discretion in how they implement those provisions. So there's both discretion at the level of which ones you implement and how you do it. Then cases are brought in national courts in relation to those exceptions as implemented in national law. So we have the next layer down, which is local judges then applying those provisions. They are meant to apply the law consistently with guidance from the Court of Justice, which can also hear references in relation to the directive. So we've got the CJEU adding a layer in here, and users might or might not have regard to all of the above. So one of the things that often gets left out in discussions about exceptions is that there are different audiences for legal commands. There's those who are involved in the law in a professional capacity, so lawyers, judges, legal academics, and so forth. And then there's those whose behaviour is regulated by the law, which I suspect will be many people in this webinar. And regular people don't have copyright statutes to hand. They don't necessarily have the case law at the sort of tips of their fingers. And so oftentimes regular people conduct themselves by references to rules of thumb, assumptions as to what the law is, best guesses, and so forth. So we need to think about, we can all sit here and bellyache about what is and is not in the EU statutes and case law, but do users know about this and pay it attention? And I think that we need to look at different user groups and do empirical analysis to really figure out what those user norms are. So in terms of where things can go right or indeed wrong in terms of flexibility and openness in the EU copyright system, let's start with the directives. And my sense is that in actual fact, if a member state was to introduce every single case in the Article 5 list from the Information Society Directive, they would have quite a robust series of exceptions. I think that there is a compelling argument that non-expressive uses are underdone. So I think that's some of the work that Ben does. I think that there are some good arguments there. But in other areas, there are some very well-drafted exceptions in terms of scope. So if a member state were to implement all of them, I think that that would overlap significantly with US fair use and other equivalent systems. Plus, when we look at the Article 5 list itself, we see a lot of language, first of all, which is standard-like, things like fair practice, proportionate, and so forth, and also language which could, whether it's a standard or a rule, cover a lot of conduct. So pastiche, I think, is the dark horse of the EU copyright system. It, I think, went into the Information Society Directive at the instigation of the French delegation, drawing from language of caricature, parody, and pastiche in their statute. But when you look at what pastiche means, it's very different as a term of art from parody. And so I've made the case, and very happy to elaborate on this, that pastiche is about non-twist and anti-twist uses It can cover mashups, fan fiction, music sampling, collage, appropriation art medleys, many other forms of homage and compilation. In the UK, we have one case to have considered pastiche, the Shazam and Only Fools dining experience case. And in that case, it was held that the particular use was not a pastiche. I'm not too sure that was correct. Perhaps the arguments it wasn't fair were stronger, but happy to talk further if people have questions about that case. But we have to start with pastiche, which could be very broad in scope. Quotation too could be broad in scope. And my direct colleague, Professor Tanya Aplin, who's also from King's College London, and Professor Lionel Bentley, have written in their book, Global Mandatory Fair Use, an argument that that quotation, in fact, shares many characteristics with US fair use. And so they really are arguing for an interpretation of quotation, which really has quite a broad operation. And so I think, for instance, their understanding of quotation would very comfortably cover the use that the Met made in the Morano and the Met case in the US, where that case was held to be a fair use. So we have, at the drafting stage, I think, a fair amount of inbuilt flexibility that's already there. But as I said, member states then choose which cases to implement and how. And this is another area where there can be issues. So for instance, to go back to quotation, Aplin and Bentley in their book express concern about civil law jurisdictions in particular, but also some common law jurisdictions that really limit their quotation exception. And they give a number of examples, and I've set out a number on the slide. But the broader point is that at the implementation stage, you can have member states narrowing the ambit of what is permitted, in theory at least, under the Information Society Directive. Then there's the Court of Justice guidance about how to interpret the directives. And here we've got sort of some different indications, some of which I think some of the earlier case law talked about the need to interpret exceptions strictly. And then that was sort of had added to a caveat, which was, but we still need to ensure that the effectiveness of the exception is enabled. And we've got cases that go kind of in different directions in terms of scope. So I think that the Court of Justice took quite a broad understanding of what is meant by a parody, by really saying that there's only two essential elements to the definition of a parody, that it evokes an existing work but is noticeably different from it, and that it constitutes an expression of humor or mockery, and that other elements that were pressed for as part of the definition of parody were rejected. On the other hand, in quotation, when it comes to quotation in Pelham and Hutter, a music sampling case, the Court of Justice very much ties quotation to illustrating an assertion, defending an opinion, allowing an intellectual comparison between the work and the assertions of the user, which is narrower than, for instance, the interpretation defended by Aplin and Bentley. Then there's what happens once the cases hit the local courts. And I think that this is certainly an area where more robust empirical analysis would be helpful, but there are examples that one can pull from different jurisdictions where courts have just taken a narrower approach than what the language of the Information Society Directive and indeed the express direction from the Court of Justice requires. So this is a French case, a recent French case in relation to parody, and the French court says a number of things. It has a requirement for the defendant's work not being confusing, which doesn't quite map onto what the Court of Justice said in Deckman and Vandersteen. It says that the parody needs to constitute an expression of humor and mockery. The Court of Justice says humor or mockery. Right, there's just these ways where even the express language of the Court of Justice may not have been applied. And then there's users doing stuff. And what is it that users do? As I mentioned, I think we really need more empirical analysis here. Bartolomeo Maletti has done an analysis of all the empirical studies currently on the CREATE copyright evidence portal, and that includes a number of empirical studies. So we're very much now on the way to creating this evidence of what users do. So let me bring this all together with final couple of slides. I think that in certain respects, I think the position is perhaps more positive than the introductory video suggested. The Information Society Directive is such that member states have the ability to pass exceptions covering a lot of different types of activity, and the language within the ISD is often standard-like. The concepts it embodies, whether they're standards or rules, are often broad. So I think that there is already openness inbuilt into the EU system. I don't consider it to be completely antithetical to the way Europeans do things or think about copyright law. That said, there are examples of issues where that flexibility and openness is stripped away through national interpretations in terms of the implementation of the ISD and also the interpretations preferred by judges. Would fair use change this? I don't know. I genuinely don't. I'm in favor of fair use, but I do think we need to ask whether or not we're going to change approaches of European judges through fair use. We need to talk about exactly how that might work. And the final couple of comments is I also think that there are those things that users can do already right now with no law reform to increase the use of exceptions. And, you know, we can talk a bit more about this if there's appetite in the chat to do so. But I do think that one of the things that I've certainly seen in the research I do is you don't need change in the law for there to be change in practices. And actually, there's often a lot of inbuilt flexibility, openness, whatever language you want to use that already exists. The question is how to tap into it. So that's me. 20 minutes, I'm afraid. But I hope that was useful and very happy to go back to any of the comments I've made to elaborate on them.
Thank you very much to all three speakers. We now have about 15 minutes left for discussion. And we have a couple of questions that have already been come through the Q&A tool. One that I might pick out is referencing the idea in the Japanese provision of centering the human enjoyment as part of the test, which so the question is basically referring whether that might be possible in Europe. And perhaps, Emily, it points a little bit towards the last point you have made, that it's not just kind of what the law says, but also how it is applied by the courts. And I am reminded by the discussion that we had in the discussion on the DSM directive on the text and data mining provision, which was precisely about this question, that some of the participants in the legislation argued that you don't really need an exception for text and data mining because these copies are not for the human enjoyment, and therefore it wouldn't even be a copyright relevant act. But indeed, in the end, the European legislator went in a different direction and went for a explicit exception instead. So I would be curious, perhaps from all three of you, what you think about what kind of are the pros and cons in that regard. And is there really a trade-off of either you have flexibility or you have legal certainty? And perhaps in the case of having the explicit text and data mining exception, rather than relying on the courts to come to the correct conclusions, as it were, the EU opted for the less flexible, but perhaps more legal certainty invoking option by not leaving it to the test of human enjoyment, but rather going with, yes, this is in scope, but there's an exception. Yeah, I would be happy for views from all of you on this question. Like, is it possible in the EU to take a similar approach to Japan?
Shall I jump in first?
Please.
So just picking up a couple of points that you raised there, Felix. So first of all, trading flexibility with certainty. I mean, that clearly is an issue when introducing an open norm. And as I hope I explained, that was the reason that the Japanese legislature decided to reject fair use and introduce an open norm which balanced flexibility with certainty. So it gives certain examples that clearly are lawful within the law, which I think is helpful for practitioners and people and businesses that have to deal with copyright. I think the issue with judgment is that often it is very opaque. If you're a practitioner, you're not aware really of court-based decisions. But very often it requires use of lawyers who may or may not be across the space that you're interested in. So I'm greatly in favor of clear codification in the law. So I think that the balance that the Japanese sort of the balance that they created is certainly helpful. Israel, which is a sort of predominantly common law system, but does have civil law influences. So in Israel, for example, moral rights is an important issue when they make fair use determinations. In Israel recently, we saw the Ministry of Justice issue an opinion. So even if you have a sort of a fair use type system, it doesn't preclude further regulations being passed to sort of clarify fair use, and it doesn't preclude, as we saw, the government issuing opinion. So obviously, and you can have guidelines as well, of course. In the States, in Israel, there's a lot of reliance upon guidelines to sort of clarify and help how one might responsibly interpret open norms. Can the European system accommodate what the Japanese have done? I would say no, not at the moment. I think if you had a Venn diagram, as my slides did, there are bits which meet in the middle, but overall they are very different, I think. There's absolutely nothing that stops, I don't think, other than will and lobbying, Europe adopting an approach similar to the US, or indeed an approach similar to Japan. That isn't the legal tradition, but it wasn't the legal tradition in any country before they introduced an open norm, and the sky has not fallen in.
Thank you, Ben. Are there any immediate comments on this question? If not, I would move on to the next one. So somewhat related to this question, certainly the use of copyrighted works for generative AI is a big topic, and I guess different jurisdictions have tackled this in different ways. And there's a question from the audience specifically about the connection to the enjoyment for the human perception, whether this would cover artifacts that emerge through AI. So let's say you have a generative AI that is trained on copyrighted work, and then the output of the AI is borrowing from that to a certain degree. But the way that I understood it, and please correct me if I'm wrong, Ben, is rather that there is also a it's specifically mentioned in the Japanese law that AI uses are permissible. So I don't know if it's really a problem, but just wanted to flag that and perhaps also give an opportunity to Emily and Chung-Lun perhaps to shed light on how these AI issues are addressed in the different concepts and to what extent copyright open norms play a role in that. Chung-Lun, would you like to start?
Yes, thank you. Very interesting topic. I think AI's when is have the deep training and is generated some content as not unauthorized by others copyright owner for training for its main is not human perception. But I think whether it is we should consider this potential and a value added activity. When you see it's just for training, but we should whether we should consider the future what the purpose for this user for in the future. It's not like the polity. It's not like the polity or the pastures. Is maybe it's just running through fundamental right to show my comment on your artwork because it's commercial things for AI to generate content even in the early stage. It's just using someone's work. So I don't know, maybe if I was the legislator, I would consider to potential add value thing to make a balance, maybe statutory licensing or something, even especially in the case where is is a copyright owner maybe are interesting in is to develop this it is the early licensing market. It's my observation for this kind of thing, but it's very advanced legislation for AI. Thank you.
Thank you. Emily, what are your thoughts on the EU legal framework? Is it sufficiently flexible to deal with a new development like generative AI?
I guess the thing is that, and I think like this is Ben's research interest, so I'm not too sure I'm the right person to throw this question to when you've got an actual expert on the panel. But I think I suppose where I struggle a bit with AI is it feels like there's certain questions being asked about the content of copyright law when there's a bunch of logical prior questions, which I'm not too sure I personally have a view on yet. So for instance, if we're talking about training AI using a whole lot of existing copyright works, and that should be permissible under some sort of text and data mining exception or some expanded version of such an exception, or that non-expressive uses should not be included within the definition of reproduction, however we get there. It sort of assumes that we want, I wonder whether it rests on the implicit assumption that we want a world full of AI generated works. And I think some of the controversies about AI producing artwork and newspaper articles and, God forbid, delivering law lectures makes us all a bit concerned that maybe we want an actual human whose brain created and fingers typed or painted or whatever the work. So I think that that to me is an issue, that there's this whole political element of AI in terms of, like, it'd be one thing if we're all going to live in a utopia where we don't have to work anymore because AI is running around doing everything for us. But I think the reality of the sort of modern capitalist economy is some people do very well and everybody else can't pay their gas bills. So I suppose that's those are sorts of things I sort of think about when I'm thinking about AI. I'm sure Ben might have some comments on much more of the specifics, although I do see that if you want to close this soon, you might not get a chance to hear much of them.
No, I think that's an excellent point, and I would be happy to hear Ben's thoughts on it. It reminds me of a discussion that came up in the context of Creative Commons licensed pictures of humans' faces and whether or not you're allowed to use them for facial recognition, where I, as a European policymaker, would say, well, no, that's a GDPR violation. So maybe there's also a question of, do all the societal questions need to be fixed through copyright law or other legal ways of regulating AI that may not be copyright? But Ben, yeah, happy to hear your views on this.
Yeah, I'll sort of answer very quickly and then move on to sort of a bigger issue. I think Article 3, which is not in the Copyright and the Digital Single Market Directive, is not bad. It has some serious flaws, and I think Article 4, from a perspective of, you know, an economy which is highly dependent already on AI, is simply not fit for purpose to support innovation in Europe. And I think for me that goes to the bigger issue and why open norms are so important. You know, AI in reality started in the 1950s, and yet even today in 2023 we have some European member states who haven't implemented the let's call them mediocre exceptions that we see in the CDSM directive. You know, that's a 70-year lag. Given that copyright regulates all forms of software and therefore all forms of technological use, I think it's absolutely imperative that Europe starts to have a mature conversation around, you know, what surely isn't too much to expect, the fact that science and technology and these developments are supported by copyright system which regulates so much. It's interesting listening to Americans who say that legislative change in the States is almost impossible, and fair use has done all the heavy lifting since 1976 to support their very successful tech companies and also scientific innovation as well. You know, because the European approach of bit by bit amendment to the law is clearly not working. I mean, if you look at all indicators around AI, Europe is far behind the States, China, South Korea, I'm sure Taiwan and Japan as well. So I guess yeah, that's sort of, yeah, I'll shut up now.
Thank you very much for your insights. Unfortunately, we're already out of time. I think there are numerous other issues that we didn't get a chance to discuss, such as the pandemic and what it means if something happens quite suddenly that puts the legislative system to the test in terms of flexibility. But as I said, this is the first webinar on the open norm work that Knowledge Rights 21 is doing. So hopefully we'll be able to continue the conversation in a similar format in the future. I'd like to thank you all for your attention and your excellent questions. And yeah, there will be a recording available through, I think, the YouTube channel of Knowledge Rights 21. So you'll be able to follow up on the discussion. Thank you very much.